So first, hello and welcome to the annual Pride CLE sponsored by the QLaw Bar Association and the King County Superior Court Judges. My name is Josh Treybig and I am the president of the QLaw Bar Association. And in my day job, I work for King County Department of Public Defense, where I am a collateral consequences attorney. I am a graduate in the class of 2016 from Seattle University School of Law. And as you'll hear, we've got Seattle U all around the table tonight. For those of you unfamiliar with Zoom webinars, and I apologize in advance for any technical difficulties because this is my first time on this side of a webinar, but please use the Q&A feature that you'll find at the bottom of the screen for any questions that you'll like to ask the panelists, and we'll have a dedicated Q&A time in the end. As you know, we are here today to discuss the recent landmark Supreme Court decisions affecting LGBTQ folks and employment discrimination. Before we get into started with any of the introductions, I wanted to first thank the folks who've helped bring all of this together. From QLaw, our Social and Services Chair, Jeremy Walker, and our Communications Chair, Ryan Barnes. And from the King County Superior Court, Judges Michael Scott and Johanna Bender, Commissioner Jenny Laird, and Beth Taylor and Heather Muero. All right. So to give some background on our two speakers this evening, we first have Charlotte Garden. She is an associate professor at the Seattle University School of Law, where she teaches labor law, employment law, and constitutional law. Professor Garden's scholarship focuses on the intersection of work, labor, technology, and the Constitution. In addition to her law review articles, she is a co-author of two leading labor and employment law casebooks and co-editor of the Cambridge Handbook of U.S. Labor Law for the 21st Century. Professor Garden regularly writes opinion and analysis pieces for practitioners and non-academic audiences. She regularly publishes case previews and argument and opinion analysis for SCOTUS blog, and her opinion pieces have appeared in outlets such as the Washington Post, the Atlantic, and NBC Think. She's a contributor to the Labor and Employment Law blog On Labor. Prior to joining Seattle University, Professor Garden was a teaching fellow in the Appellate Litigation Clinic at Georgetown University Law Center, where she also received her LLM. Professor Garden then clerked for Judge Thomas Ambro of the U.S. Court of Appeals for the Third Circuit. She's a graduate of NYU Law School and McGill University. Also joining us, we have Brian Sutherland. He's an Assistant Attorney General in the Civil Rights Division of the Washington State Attorney General's Office, where he works on affirmative civil rights enforcement litigation in several substantive areas. After graduating summa cum laude from the Seattle University School of Law in 2006, he served as a staff attorney for the ACLU Voting Rights Project in Atlanta, focusing on state and federal constitutional voting rights litigation. From 2009 to 2012, he served as a trial attorney for the U.S. Equal Employment Opportunity Commission in Miami, where he litigated employment discrimination and retaliation cases on behalf of the federal government. In 2012, he returned to Atlanta, where he joined the law firm of Buckley & Klein, now Buckley Beal. He has represented numerous individuals in constitutional civil rights cases and cases brought before the Voting Rights Act of 1965, Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, the Americans with Disabilities Act, and Family and Medical Leave Act, as well as state tort law. He has tried multiple cases to jury verdict and taken appeals to the Georgia Supreme Court, the 11th Circuit Court of Appeals, and the United States Supreme Court. Prior to returning to his native Pacific Northwest and joining the AG's office, Mr. Sutherland served as lead counsel and counsel of record for Mr. Gerald Bostock in proceedings before the Northern District of Georgia, the 11th Circuit Court of Appeals, and the United States Supreme Court. So thank you both for joining us. We really appreciate your time and expertise on this matter. I think to get us started, Professor Garden, could you help us understand sort of a background of how we got to this case in constitutional law and employment law cases?
Yeah, and thanks so much for inviting me to do this. I'm really excited to be here speaking with both of you. So I'm going to keep this short because I know this isn't like the most exciting. This isn't like the most exciting part of this CLE, right? So I want to get to hearing from Brian, and I'm sure you all do too. So very big picture. Title VII prohibits employment discrimination because of sex. And after the Civil Rights Act, which includes Title VII, was enacted, decades of litigation about whether that language, because of sex, as well as other state and federal civil rights laws with similar language, covered discrimination against LGBTQ people began. The plaintiffs in those cases met with little success during the 70s, 80s, 90s, early 2000s. In the Title VII context, courts often focused on what Congress might have been thinking when it first enacted the Civil Rights Act, right? Would those legislators likely have thought that the statute covered discrimination based on sexual orientation or gender identity? But then, right, thanks to decades of social movement advocacy, things started to shift. And of course, that shift wasn't just in the courts, right? It's also in agencies and state legislatures, but it's also in the courts. So in the run-up to the Supreme Court granting cert in Bostock, Zarda, and Harris, it was starting to seem or sort of feel like kind of a wave in the federal courts in favor of seeing Title VII as covering discrimination based on sexual orientation, gender identity, or both. So I want to just flag two Supreme Court cases that I think were especially important in the run-up to Bostock in the Supreme Court. Although one of them sort of interestingly ended up not playing as much of a role in the majority decision as I think some of us expected it to. And that case is Pricewaterhouse v. Hopkins. That's a case from 1989. The plaintiff in Pricewaterhouse was a woman named Ann Hopkins. She worked at Pricewaterhouse. She was a good employee, good at her job. When she went up for partnership, she had a pretty strong record. However, some Pricewaterhouse partners thought that she wasn't feminine enough. The record suggested that some of them called her macho. They said she should go to charm school. One partner said he didn't like her swearing because he, quote, didn't like a lady using foul language. And a plurality of the court in that case said, well, sex stereotyping is a form of sex discrimination that's covered under Title VII. You can sort of think about that in the usual disparate treatment frame, right? It's discrimination for an employer to hire a man who swears, but not a woman who swears. You can also think about that as standing for the proposition that Title VII covers, sex stereotyping generally. It covers assumptions about how a man or a woman should act. So the argument, right, sort of pushing Pricewaterhouse forward, was really that discrimination based on sexual orientation or gender identity is really a form of sex stereotyping, right? It's the expectation that, for example, men will be in relationship with women, or that people who are born with certain genetics or certain bodies will later have a certain gender identity and presentation. And then the second case I want to briefly talk about is a case called Oncology Sundowner from 1998. That case had to do with whether same-sex sexual harassment was discrimination because of sex under Title VII. Here, Oncology worked on an oil platform, and he was subjected by his coworkers to a really quite vicious and horrifying campaign of sexualized bullying, abuse, and harassment. So in a unanimous decision by Justice Scalia, the court held Oncology had stated a claim under Title VII, even though he and his harassers were both men, and even though it was hard to know what would have happened to a woman who worked in Oncology's job. So the court wrote that, quote, male-on-male sexual harassment in the workplace was assuredly not the principal evil Congress was concerned with when it enacted Title VII, but statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils. So the idea is that even if you had gone back and asked, the legislators in the early 1960s whether they thought that they were covering situations like Oncology's, and they would have said no, right? That's sort of not the end of the story. It's maybe not an important part of the story at all, because what's important is the text of Title VII, right? So you can see how that would be a useful case if you are relying on primarily the text of Title VII in order to make a case that discrimination based on sexual orientation or gender identity is discrimination because of sex. So that's my very brief overview. And I will leave that there for now.
Great, thank you so much. Brian, I wonder if then you would take us right into this case, give us some background on how we got here, what brought Mr. Bostock into this case, and maybe also mention the other two plaintiffs who were tragically not around to see this case come to fruition.
Sure. And can you hear me okay?
Just fine, thanks.
Very good. And thanks so much for inviting me to be here. It's great to be here with you and Professor Garden and all the attendees. I want to also maybe just add in a few things that were sort of, I think Professor Garden has laid the foundation for the Supreme Court's interpretation, but maybe fill in a little bit of what was going on in the lower courts with respect to claims of employment discrimination on behalf of LGBT folks. In the 70s, early 70s, after the Civil Rights Act was first passed, the EEOC actually took some charges of discrimination by gay and lesbian employees who were alleging that they were discriminated against because of their sex. There's some really interesting discussion in the amicus briefs filed in Mr. Bostock's case that discuss this history and, ask some questions about whether or not it really was completely unexpected that Title VII would apply to LGBT folks. But nevertheless, some lower courts, the circuit courts, had held in a couple of different cases that sexual orientation was not a protected class. But these cases were not, real thorough considerations of the issue. They sort of assumed without even really, analyzing it too closely that it was not covered. And there was about 3 of these decisions, and one of them had sort of been interpreted. It actually held that there was no cause of action for discharge because of transgender status or gender identity, but was then interpreted to sort of apply also to sexual orientation. So this was what the lower courts were doing as the Supreme Court was sort of interpreting Title VII more expansively. And one case I would add to the mix in terms of cases in the 80s that matter a lot is Vincent versus Meritor Savings Bank. So this was the case in which the Supreme Court held that the sex discrimination prohibition in Title VII extended to encompass sexual harassment. So, not necessarily firing somebody or not hiring them or paying them less, but, unwanted sexual comments and the quid pro quo and that sort of thing. The Supreme Court interpreted the language of Title VII, which says terms and conditions of employment shall not discriminate in the terms and conditions of employment on the basis of sex, to include that theory of discrimination, even though it wasn't set forth in the statute. And the opinion's interesting too, because Justice Rehnquist talks about the legislative history of the sex discrimination prohibition and sort of kind of admits that there isn't a lot there. There was not a lot of discussion about what exactly Congress meant with that provision. So the lower courts have said no. Those that have spoken to the issue in the 80s, by the 80s, have said no, there's no sexual orientation protection under Title VII. The Supreme Court has said, well, the Title VII sex discrimination prohibition is broad enough to include sexual harassment, even though that's not spelled out in the statute. It's broad enough to encompass discrimination based on sex stereotypes, even though that's not in the statute. And then, of course, Congress amended Title VII in 1991 and essentially, approved of those decisions, didn't disturb them, except did disturb the Price Waterhouse decision on a different point, which had to do with the burden of proof for an affirmative defense to discrimination, but didn't touch the issue of sex stereotyping. Price Waterhouse was a fractured opinion in which just a plurality of the justices really spoke to the sex stereotype theory, but the other justices joined in the judgment and I would say talked about sex stereotyping, even if they didn't say specifically this is sex discrimination that violates Title VII. And then after on-call in 98, when Justice Scalia wrote for a unanimous court that even though same-sex sexual harassment was not on the mind of Congress, maybe when it passed the Act in '64, it was still prohibited. I think that was kind of the nail in the coffin for the interpretation of Title VII, that sexual orientation discrimination couldn't possibly be included. And so then in 2015, the EEOC issued a decision in federal sector EEOC case. So federal employees file EEOC charges with the commission itself, and those get heard by the commission as a tribunal. And so the EEOC issued a decision interpreting the sex discrimination prohibition in the federal sector provisions of Title VII, and sort of went through those developments we've just talked about and said, based on all of this, it's sort of, we revisit and reconsider and decide now that in fact sexual orientation discrimination is sex discrimination that violates Title VII. And right after that, in 2017, the Seventh Circuit in Hively reached the same conclusion, as did the Second Circuit in the Zarda case. What's interesting, I think, about the ultimate decision in Bostock, to me, at least one thing to me, is that some of the important points relied upon by the Second and Seventh Circuits were not part of the Supreme Court's opinion. But just as Professor Garden mentioned, sex stereotyping was discussed quite a bit, and also the associational theory of discrimination, that an employer can violate Title VII by discriminating against a person based on her association with a person in another protected class. So a lot of older cases and some more recent cases involved, somebody getting fired because they were involved in an interracial relationship. And the reason for their discharge was because of their association with a person of a different race. And so the Second and Seventh Circuits found persuasive the argument that a person who is gay or lesbian is being discriminated against because of their association with a person in a protected class, which is another person with a sex. And because of that person's sex. So that was where we were. And I should say also where we were, we being anybody who was working on plaintiffs' employment cases, was in the position prior to Mr. Bostock's case of having to argue that discrimination was taking place against a plaintiff employee, not because of sexual orientation, because that would be okay, but because of that person's failure to conform to a sex stereotype. So if derogatory and harassing comments were made against a gay male plaintiff, for example, those comments may or may not be found by the court to support an actionable sex stereotype claim, or they may be found to be indicative of a sexual orientation discrimination claim, which you couldn't bring. So the case law was all over the map, really. And it was sort of it was highly problematic, and I think really showed the wrongheadedness of the course of the jurisprudence, that sex stereotyping was okay and LGBT plaintiffs could make those claims, but they couldn't make claims just based on being LGBT. So that was where we were. And then as far as Mr. Bostock's case, and I do want to say a few things about Mr. Bostock because he's really a wonderful person, and it was a real honor and privilege to represent him. He was somebody who was very passionate about helping kids in the foster care system, in the juvenile court system, be supported during those crisis times that they were in. He had been a social worker with the Georgia Department of Children and Family Services for several years, and he got involved with the CASA program, which is Court-Appointed Special Advocates, and was very successful in that endeavor, and actually brought the program he was managing, which was in Clayton County, Georgia, to a point where there was a volunteer for every kid that was in the juvenile court system in Clayton County, which was a first in Georgia at that time. And it was after he joined a gay softball league, the Hotlanta Softball League, that he was accused of improper expenditures in his job performance. And the evidence, he is only now going to be pursuing his case in the trial court, but The allegation was that these allegations against him were false, and they were just a pretext for sex discrimination, sexual orientation discrimination, constituting sex discrimination. And because he was fired and he was out of work. And so Mr. Bostock filed an EEOC charge and in fact filed his own complaint in the district court in Atlanta pro se. And it was at that point that our firm was retained and we began to represent Mr. Bostock. And the case at that time, the defendants moved to dismiss the case for failure to state a claim. And we amended the complaint to allege only sex discrimination in violation of Title VII, not including the sex stereotype theory. And the court stayed, the magistrate judge granted the motion to dismiss, or issued a report and recommendation recommending the complaint be dismissed. And the district judge stayed consideration until another case in the 11th Circuit had been decided. There was another case called Evans versus Georgia Regional Hospital. And that case raised the same issue of whether sexual orientation discrimination was sex discrimination under Title VII. And after the 11th Circuit upheld a motion to dismiss or a dismissal of that case, and then denied rehearing en banc, the court in Mr. Bostock's case lifted the stay and adopted the report and recommendation and dismissed Mr. Bostock's case. We petitioned for hearing with the 11th Circuit, and we petitioned for en banc hearing in the first instance, and that was denied. And so we put together and filed the petition for cert with the Supreme Court. A few days later, the employer in the Zarda case in the Second Circuit in New York, and I guess just to back up a little bit and give a little bit of background on that case, Mr. Zarda was a skydiver. He was with one of those companies that would take folks out to skydive if they want that thrill. And he was working one day with a woman who I think seemed to be maybe a little worried about him or felt a little uncomfortable. And he said something to the effect of, "Well, don't worry, I'm gay." And then he was later fired. And he brought claims under the New York state law as well as Title VII, and he prevailed. And then sadly, he later passed away before the case came to the Supreme Court. But the Second Circuit had held en banc that Title VII does prohibit sexual orientation discrimination. And the losing employer filed a cert petition very shortly after we filed our petition for Mr. Bostock. And then a couple of weeks later, Justice Anthony Kennedy announced retirement. And so there was some time there while I think then Judge Kavanaugh was nominated and the confirmation hearings took place. And then after that, the court considered the petitions and did what's called the relist, which is not making a decision to grant or deny, but to hold off and consider the petition again at the next conference, and did that several times. I think it was at least a dozen times that it was relisted before the court eventually granted cert. So that's the story of some law on LGBT cases under Title VII, and Mr. Bostock and Mr. Zarda's case and how they got together and went up to the Supreme Court.
I was wondering quickly before going back to Professor Garden, but given that change of who was sitting on the court, what were you thinking during oral arguments? Is this the outcome you were expecting? Was 6-3 a surprise to you?
I was asked this question at the National Press Club the day of the oral arguments, and I said something to the effect that it probably ought to be 9-0 in favor of Mr. Bostock. And I was, maybe joking a little bit, obviously, but the reason being that the on-call decision was a 9-0 decision, and interpreted the plain meaning of the statute and applied it, even though it may not have been the expected result for people who passed this law, but commitment to the text of the law requires that result. So to answer your question, I I didn't know what it would mean, but I was always confident in the arguments.
Professor Garden, I was wondering if you could comment on any of that based on the case as it was heading to the Supreme Court, based on the oral argument, based on what you know about the folks up there. What were your expectations? Were you surprised by the outcome or the decision being 6-3?
You know, it's funny, on a panel on this case, you know, post argument but pre-decision, I was like really having a hard time making predictions because I found the argument just like really difficult to sort of say, you know, okay, you know, 6 of them are leaning one way and 3 another or something like that. So, you know, it's sort of like Brian was saying, I felt on one hand, like these arguments seem extremely strong, right? Like very solid on every, you know, on the text of the statute, which the justices that are more conservative say is the thing they care the most about. But leave it, you know, but reading the transcript of the oral argument, I just felt unsure. So I guess I would love to hear from Brian, like, you know, when you sort of, you know, you sort of like walk out of the court and you're like on those big steps, you know, whether you felt like, okay, it felt like they, you know, it felt like we had them based on the questions they asked.
You know, if I could predict these things, I would probably be, I don't know where else I would be, but I don't know. But I will say that, you know, it was an incredible experience to represent someone in the Supreme Court, just in general, but it was really a wonderful experience because the justices were so engaged and there was a lot of questions being asked. And, you know, in the briefs, a lot of argument was made by the parties and by the amici about hypotheticals. You know, if you consider a person's, you know, and this goes back to the Manhart case, Manhart versus City of Los Angeles Water Department, which is the case from the 70s where the city was sued for sex discrimination because women were being required to pay more into the pension because they tend to live longer. And the court said that Title VII involves a simple test, which is, you know, but for the person's sex, would they have been treated that way? And so a lot of the argument by the parties and the amici was about, you know, if you change a person's sex, would the result have been different with this decision or that decision, or do we have to change the sex and something else in order to arrive at what Title VII is really seeking to deal with? And I felt that the justices were engaged with those questions, or with those hypotheticals and the questions that they asked. And so, you know, I can't say that I knew what was going to happen, but I do know that I felt that we were heard.
I guess one thing I notice every time I look at the transcript is like how early and sort of disappointingly to me, the justices started asking about like, well, how will we deal with locker rooms and bathrooms? And they actually asked those questions of Pam Carlin, who was representing you know, Bostock and Zarda. And she's trying to answer them in a way that sort of made sense for her clients, for whom you know, it would be very unlikely that they would be directed to use a bathroom or a locker room that they didn't want to use. You know, that was inconsistent with their gender identity. And finally, she says to them, well, maybe you should ask the lawyer for Amy Stevens, right? Maybe you should ask a person who's trans, the lawyer for a person who's trans, because I am representing 2 clients who are gay. And like that sort of took my breath away, both in the sense that, you know, that wasn't an issue in the case, and that, you know, they sort of were so anxious to get to it that they sort of got into it before they were talking to, you know, the lawyer for Ms. Stevens. So I don't know. I mean, you know, and then in the decision, you know, that gets like specifically noted as here's an issue we're not deciding. So, you know, I mean, it's obviously like a great decision on the merits. You know, I just sort of wish that they had been a little less sort of hung up on bathrooms and locker rooms.
Well, I remember the briefing, and I remember so many things of that nature presented by so many different amici. And I think it was right that the court didn't address most of that because of the fact that it wasn't really presented. And we argued some of the details about some of these situations, such as bathrooms, Title VII has different provisions, and one of the provisions is a bona fide occupational qualification provision. And there's other case law dealing with other kinds of situations in which sex plays a role in decision-making in the workplace. And it just was not, I think the court's decision was correct in that those questions would have to wait for another day because they were not presented by this case. This case was just whether or not, and now I'm cheating and giving my phrasing, but whether or not you have to consider a person's sex when thinking about her or his sexual orientation, whether or not it is sex discrimination. And I think it was right to stick to that narrower question that was presented. But there certainly was a lot of talk about those other issues and a parade of horribles, right?
I guess the other moment that in retrospect seemed like a big deal was on Pam Carlin's rebuttal, where somebody, I think it's maybe Alito, asks her, what if on a job application you had an employer who asked, are you gay? And didn't ask, what is your sex? And an applicant checked like, yes, I'm gay. And so the employer is deciding whether to hire them, knowing only that they're, LGBTQ and not what their sex is. And Pam Carlin's answer was something like, maybe that wouldn't be sex discrimination, which comes up, Justice Alito raises that in his dissent. And so, in retrospect, that moment, right, because it's almost at the very end of argument, one of the last questions to be asked, Pam Carlin must have been like thinking, oh, I'm about to be done, right? And this question comes up that, gets quoted in a dissent as a concession. I guess I wonder whether that seemed like a big deal at the time, or whether that seemed like, oh, it's just another one of these, hypotheticals in a string of hypotheticals. Obviously, there are no job applications like this, so who cares?
The oral argument was really enjoyable because it was actually, and I did not expect this. I did not expect it to be as amusing as it was. There was a great feeling in the courtroom about, everybody was engaged, as I mentioned, the justices were engaged and asking a lot of questions, and there was some funny moments. There was some really funny moments. And I don't know if you can tell from the transcript, but, in the beginning of the oral argument, Pam Carlin gives a great summation of the argument, and then there were no questions from the bench right then. And so Pam Carlin said, well, if that's everything, I rest my case, or something to that effect. And it was really just only a few minutes in, and everybody chuckled at that. I think that, and also Mr. Cole, who represented Amy Stevens, also had a wonderful dialogue with the court. So I think that, you have your thoughts about what is significant being shared between the bench and the counsel, but you're always surprised. I mean, maybe not always, but many times surprised by what ends up being significant in the opinion. Like I've said, there was a lot of focus on the sex stereotype theory and a lot of focus on the associational theory, and some discussion about that in the oral argument, and not part of the decision. So you never know. You just have to be prepared. I'm sure that our judges would probably say the same for anybody appearing in front of them. Always be as prepared as possible, even though it may not end up mattering in the opinion.
As we start to pivot toward a little bit toward looking at the future, I was wondering, Professor Garden, could you comment on anything specific you see in the fact that the Chief Justice was on where he was on this decision, and that Gorsuch was on the majority in this decision, and his authorship of it? If you read anything into that, either their sort of their framework for thinking, their judicial philosophy, or what we should expect from the future from them.
Yeah, I mean, I think that's been this sort of interesting exercise in trying to read the justices' minds post-decision, and try to figure out, especially with respect to the chief, was there some kind of triangulation here, or what was the move, or was there was there either a primary or a secondary reason other than just believing the merits were correct for his decision. I guess one thing I'm going to say is that, Justice Gorsuch is, obviously a committed textualist. That's how he talks about his philosophy of judicial decision-making. And that really comes out in the opinion. One often thinks about a textualist approach as being associated with, the conservative legal movement, and with a more purposivist approach being associated with this more liberal and progressive legal movement. Here Justice Gorsuch says, okay, let's take textualism and apply it to the words of Title VII, and he finds them to be clear, right? He finds no ambiguity. The decision sort of reads like a series of discussions of, dictionary entries. So we talk about because of, and we talk about sex, and we talk about individual, all in the context of, what does Webster's third say, or, how have we defined this word in the past? And actually less discussion, right? So less discussion of Price Waterhouse and sex stereotyping, right? And more of, okay, let's go back to the language of the statute. And so that seems very consistent with his general approach, or his general judicial philosophy. It's also consistent with something he did the previous term in a case called U Prime v. Oliveira, which was a case about the Federal Arbitration Act. It had to do with what the word employment meant in the 1920s, whether it had the same connotation that it does today, that an employee is someone who's not an independent contractor. And in much the same way, he goes back to contemporary dictionaries and contemporary cases and so on, and says, well, here's what the word employment meant. It turns out it didn't have this as distinct from independent contractor meaning, and so we should read this word the same way. The interesting thing about that opinion was that Justice Ginsburg concurs specifically, and her concurrence seems aimed at making the point that in this case, right, and that in Bostock, one should think about language set in time. And so it was interesting to me that, I think clearly she was worried about what Gorsuch would do in this case, based on his approach to textualism in New Prime, and that ended up not being so much a concern. And one possibility for what the chief did, perhaps the chief thinks that a lot of very high-profile 5-4 decisions are bad for the court's legitimacy, and so maybe that was, a consideration that he had in mind, right? I mean, I could understand that. Obviously, there have been, including yesterday and today, right, a large number of very high-profile 5-4 decisions. Although I guess today 7-2, and so maybe he was worried about that, right? Maybe he wanted to sort of dial down the kind of perception or the sort of discussion about the court's politicization. I don't know though. I mean, I don't know what the chief said about when his notes and papers will be available to the public, if ever. Some justices, say something like, after I die and everyone on the court with me dies, 50 years later, I'll release my papers, and maybe then you find out something more about what they were thinking. But I'm sure it's, just going to be us. We're just going to have to speculate until then.
I wonder if then, as we pivot toward the future, is there anything in particular that either of you found in the dissent that's worth noting? Anything that might provide fodder in future cases in any direction? Any insight, I guess, into the dissenting opinion? I guess we'll
I mean,
start.
I guess what I thought was interesting about the dissents were they were like respectful, in the sense that, you know, if you look at some of Justice Scalia's dissents in cases about LGBTQ rights, the rhetoric is sort of dialed up to 11, right? It's very, you know, this is a culture war and the court is taking sides, siding with the elites, you know, versus traditional values. And these dissents didn't read like that to me. It felt more like, you know, this is a happy day for a lot of people, but we don't think it's the appropriate role for the court, you know, a more toned down kind of approach to dissenting in the case.
Brian, any insight that you got out of the dissent?
Yeah, I mean, I think I found them very interesting. I thought that Justice Alito's dissent was interesting because of the extent to which he sort of investigated, you know, what members of Congress thought about the statute at the time it was passed. And there was discussion about kind of peripheral sources of information about that. And it made me think about the fact that, you know, people have been talking for a while about, you know, textualism. We're all textualists now. Justice Kagan said that. And the idea of looking at legislative history is something that I think is out of fashion, obviously, in statutory interpretation. But I think that as much as folks say that, it seems to me that whenever I read a decision, there's always some discussion about these matters and about the legislation and the legislative landscape around a piece of legislation. It's as if some jurists feel the need to cover that base too, even though everybody agrees that we don't need to look at that and it's not helpful and it's not, you know, but it's still discussed. You know, Justice Alito's dissent makes the point that the discussion is not to engage in a discussion of legislative history, but to talk about what members of Congress thought their words to mean. I don't know how much of a difference there really is, but it made me think about it. I thought that Justice Kavanaugh's dissent was interesting because at the oral arguments, he asked the question about ordinary versus literal interpretation, or the ordinary meaning of a word versus the literal meaning of a word. And then obviously his dissent in Bostock explains that thinking at length. You know, I don't know what that means for the future, but I think it's, you know, it's kind of it's an interesting gloss on textualism, I suppose, you know. I found it interesting, the majority's opinion, though, in terms of, you asked the question about textualism from Justice Gorsuch, and, you know, there was another decision, I think it was last year, and it was Argus Media, and it was a decision about the Freedom of Information Act and the proper scope of the provision relating to confidential information, if I'm not mistaken. And there's discussion in one part of the opinion, also written by Justice Gorsuch, about the statutory history and what had happened to the act after it was originally passed and how that was a clue to the meaning of the words used in the statute. We made arguments in our brief, in Mr. Bostock's case, about the statutory history of Title VII because, as we argued in the briefs, it demonstrates an expansive scope of the meaning of the sex discrimination provision. So in 1978, when the Pregnancy Discrimination Act was passed, it was to abrogate a Supreme Court decision that had narrowly interpreted the sex discrimination provision to not encompass pregnancy discrimination. And it gave a more broad definition of sex discrimination. And in 1991, when the amendments were passed, the definition of sex discrimination was untouched and had been interpreted broadly already in the cases in the 80s. And so I thought this was, you know, we argued that this was you know, in the same vein, a clue to the meaning of the reach of the sex discrimination prohibition. But you know, the court did not apparently find that necessary to deal with in order to define the scope of the sex discrimination prohibition. And I suppose some can argue that that's because it was not ambiguous. There was no need to look further into statutory history or, you know, God forbid, legislative history to answer that question. So I'm glad they agreed that it was a clear answer.
I wonder then, going back to Professor Garden, what cases should we be looking at coming down the pike? I wonder if you could also just discuss any impact that might have come from the decisions that have been issued in the short period since the Bostock decision.
Yeah, definitely. I mean, so, you know, in one way, new cases to look out for are almost kind of outlined in Justice Alito's dissent. He lists like all of these analogous legal provisions and sort of like, oh, well, here's a place you could look if you were looking for new cases to bring. But, you know, to me, one of the big issues is going to be one that Justice Gorsuch noted as, you know, an issue for another day in his decision, and that is what to do about, you know, religious employers and religious accommodations. So yesterday, the Supreme Court decided 2 cases about the ministerial exemption, and those are going to be very significant to LGBT people who work for religious entities. So the ministerial exemption is something it's been around for a while, but it was recognized by the Supreme Court in 2012 in a case called Hosanna Tabor. And the big idea is that under both religion clauses of the First Amendment, the government shouldn't be able to interfere with a church's choice for who will be its minister. And, you know, if you're thinking about, you know, say whether, you know, a woman could sue the Catholic Church for employment discrimination because they won't hire her to be a priest, you might say, well, of course, you know, institutional religious freedom demands that the Catholic Church be able to have as part of its religious precepts that only men will be priests, and Title VII can't override that constitutional right. The ministerial exemption goes further in 2 ways. First, it doesn't require the religious institution to say that hiring the person would be inconsistent with its religious practice. It doesn't have to offer any reason for why it doesn't want to hire the person. And so it can, in fact, be, you know, well, we don't want to hire this person because, you know, they're older, and it's not because there's something in our religion against older people being ministers. It's just that age discrimination. Or we want to fire this person, as was the case in, or as was alleged to be the case in one of the cases from yesterday, because they're going to undergo cancer treatment, right? Of course, there's nothing in the church's faith that concerns cancer treatment. So there's that, right? So we're not going to ask why, right? We're not going to ask whether there's an actual conflict with religious doctrine. And secondarily, we're not talking about just, you know, the priest or the minister. Ministerial employee has a broader definition. And the question of who is a ministerial employee is one that the court didn't really tackle in the 2012 case. In that case, the plaintiff was a woman who had worked at a Lutheran school. She'd started out as what was called a lay teacher, but she eventually chose to get some fairly extensive religious training, and she became a called teacher. And when she became a called teacher, she did things like take a special tax exemption for clergy that's available, you know, on her taxes. And she, you know, sort of held herself out, and the school held her out as a teacher whose job was to teach religion. And so the court said, well, you know, we know she's ministerial, and therefore, you know, that's a complete defense to the claim under the Americans with Disabilities Act that the teacher had brought. But the court says in 2012, we're not going to decide, right, who else would qualify as a ministerial employee. So some of the circuit courts, including the Ninth Circuit, where both of the cases that were decided yesterday came out of, sort of looked to this Hosanna Tabor case as a real guide. They really looked for, okay, if the employee who's bringing the case is very similar to the employee in Hosanna Tabor, then we'll say they're ministerial. But if they are less involved with teaching religion, these cases both came out of schools, then we'll say they're not, and they can continue with their discrimination claim. So the Supreme Court decided that the definition of ministerial employee is significantly broader than the factors in Hosanna Tabor suggested. The two cases yesterday both arose in the context of employees in Catholic schools. And the court noted that the school's institutional mission involved teaching religion, that the school's handbook said that the teachers would be involved in teaching religion, that the teachers spent, some time during, the average school week on religious activities or escorting kids to Mass or praying with kids at Mass, that the teachers were charged with guiding the students by word and deed, and that their title doesn't matter. So it's hard to imagine that wouldn't encompass kind of every religious school teacher, at least at the K through 12 level. I think there are much more difficult questions in higher ed because there are just like so many varied approaches to religious education in universities. So it's clear after yesterday, right, that there are going to be a lot more ministerial employees. And if you are a ministerial employee, then you can't bring any employment discrimination case, or you can't bring other cases under protective employment statutes, other civil rights statutes. There are some questions about other, like Fair Labor Standards Act type claims. So there's that, right? So there's the ministerial exemption. Then there's also the Religious Freedom Restoration Act, RFRA. That's a federal law. It was enacted following the Supreme Court's decision in Employment Division v. Smith. Employment Division had held that religious adherents don't have a right to exemptions from neutral and generally applicable laws that conflict with their religious practice. In that case, an employee had been fired from his job because he had used peyote as part of a religious ceremony. And when he went to apply for unemployment benefits, the state of Oregon said, well, you were fired for cause. The activity that caused you to be fired is a crime under Oregon law. And Smith said, well, but, what about a religious exemption, right? Because, it wouldn't be consistent with the free exercise clause of the First Amendment to apply, your generally applicable criminal statute to me in this context. Justice Scalia said no, right? Justice Scalia came up with this formulation that the free exercise clause does not require accommodations or exemptions from neutral and generally applicable law. And not long after that, right, Congress passed this Religious Freedom Restoration Act that entitles people to exemptions from the application of federal law by the executive branch, unless the executive branch can kind of meet strict scrutiny. And so one question that has arisen in some cases, including in Harris, right, in Amy Stevens's case in the district court and in the Sixth Circuit, is how RFRA applies when the EEOC brings a discrimination case on behalf of somebody. So the district court found like a series of questions about how to apply RFRA, and it resolved each one of those questions in a way that was as protective of religion as possible. Essentially saying first that, courts shouldn't be in the business of questioning whether a federal law imposes a substantial burden on somebody's religion, that sort of only the person can say what's substantial and say what's a burden. And then sort of came up with this theory that the EEOC should have gone to the funeral home where Ms. Stevens worked and like tried to negotiate some kind of accommodation with them rather than just saying like, this is Title VII, you must comply with it. And so obviously if that view were to take hold, that could also be quite significant, right? I mean, note that there's nothing in RFRA that says we only apply to, churches or sort of like nonprofit religious institutions, right? Harris Funeral Home was a for-profit business. And so, sort of think the Hobby Lobby case, right? Like multiplied in corporate, in businesses or by employers who, own a company, who are religious and who, claim that complying with Title VII would be a substantial burden on their religious practice. So those are I think the issues that we're going to see percolating in the religious freedom context. I think there's some clarity when it comes to the ministerial exemption now, although that clarity means that the ministerial exemption is going to apply to a lot more people. There are some questions about RFRA and how to apply RFRA. One thing I will say about that is, part of the reason RFRA was a big deal in Ms. Stevens' case was that the EEOC was prosecuting her case rather than her prosecuting it herself. That's often not the case, right? Often the EEOC issues a right to sue letter and the person sues on their own behalf, or they get involved in the litigation on their own behalf. And so, that's one limitation on how RFRA will apply in Title VII.
I just wanted to say briefly to all of our attendees, a reminder to put your questions for our panelists in the Q&A box. Some of the questions that have been asked and kind of already weaving into our conversation here, and I've got a couple more, but for any of our attendees, please feel free to submit any of your questions into the Q&A box. One of the other questions I had, if I understood it correctly, the court was really saying no, that we didn't, the writers of the Civil Rights Act would not have interpreted sex to include LGBTQ people, and that's not really what they were looking at of the way that they would have interpreted that. And I think a lot of folks will readily say that the Supreme Court, the legal system at large, does not advance nearly as quickly as our society does. And certainly we see now that the definition of gender or sexual orientation is much more of a continuum than it certainly would have been in 1964. So I'm wondering if either of you see in any way that this decision came out that as a continually fluid definition or understanding of sex or gender, if that is complicated or complicated by this decision at all.
Well, I guess one thing during oral argument, Justice Alito asked something like, wouldn't it basically be a really big deal if we ruled for the plaintiff? And Gorsuch responds to that in his opinion by saying something like, maybe this wouldn't specifically, this outcome wouldn't have been specifically anticipated, but the Congress that passed the Civil Rights Act knew it was doing something big. And when Congress knows it's doing something big, it doesn't have to, it makes clear in the text that it's doing something big. It doesn't have to specifically list every iteration of big thing that the statutory language reaches. So I think that helps respond to the sort of dynamism in our society that your question was getting at.
Anything else you'd add to that, Brian?
Yeah, I think the majority opinion sort of raises the question, though, that is it really true that nobody could have expected it? But sort of puts that aside to make the point that Professor Garden just made. And I think that the other piece of it for me is that I think about one of the other decisions that was a big textualism decision, which is Pennsylvania versus Yeski, where the folks brought claims under the Americans with Disabilities Act against the Pennsylvania Correctional Institution, and the Justice Scalia wrote the opinion in that case too, and said that the argument was made that, well, this nobody could have Congress did not expect the ADA to apply to prisons, It might have said institutions, but it never intended it to apply to prisons, and we can be pretty sure of that. And Justice Scalia wrote that, even if that's true, it doesn't matter, right? Because a law that applies to things that the drafters did not expect doesn't demonstrate vagueness, it demonstrates breadth. So I think that, I think it means that textualism is, that we really are all textualists now, and that it does mean that textualism, it's an affirmation that textualism can lead you to conclusions that are unexpected, but that's okay.
I just saw Carol Burton raising your hand. If you could type your question either in the Q&A box or the chat box, I can be able to get to that. Another question that we received, I know one of the other LGBTQ issues that has made a lot of news lately has been the Trump administration's seemingly off-the-cuff banning of trans folks in the military. Is there any way that this decision impacts that?
Well, oh, that's funny. When you started to ask that question, I thought you were going to ask about the HHS rule and coverage of like medical treatment for transgender individuals. And I'd rather answer that question, so I'm going to do that. I think the answer is yes, right? The question in that case is whether the Trump administration's repeal of non-discrimination requirements would violate the ACA's prohibition on sex discrimination, right? And I think under this case, the answer, there's a very strong case for the answer being yes.
Any insight to the trans folks in the military or further response to Professor Garden, Brian?
I have to confess to you that I am, you may have mentioned it. I'm relatively new with the Attorney General's office, and I am aware of the Attorney General's office being involved in a case related to that, and I'm not. I don't know. I don't want us to speak to it because I'm not as well studied as I'd like to be. And of course, I should say that all of my work on Mr. Bostock's case predated my time with the Attorney General's office. And maybe some things I might like to speculate on that I won't for you just because of that, but no
okay.
comment. And I'll say one other thing about this. I mean, the reason I'm dodging is that there's some Supreme Court case law that I did not review before coming here today that has to do with whether it's permissible for the military to discriminate based on sex. And I want to go back and look at that. It's a case called, I think, Rockster v. Goldberg, something like that. And so, I don't want to say more than I know.
Is there any kind of pushback either legislatively that would be possible on the state or federal level, or a way that like an executive action or some sort of unilateral legislative authority might have any impact on that? Is there any way around this decision, or is this decision a hard stop on anything like that?
Bostock, you mean?
Yes.
I mean, Congress could change Title VII, but I can't imagine that would happen. So I think this is, I think we can rely on this.
Let me see what other questions we have here. I had a question. When we consider the notion of judicial activism, do you think that considering legislative history as it informs statutory and case history, specifically within dissenting opinions, means that conversations automatically supersede strict textualism?
I mean, I think if you asked the dissenters, they would say, the language isn't so clear. And so, we have to kind of like go to the videotape to figure out what happened. Or they would say, we are doing textualism. The majority didn't do it right. We're doing textualism right because, textualism ought to be applying the language as it was understood by, people at the time, and the language as it was understood by people at the time was to not cover these cases. So, you know, I think I think if you asked the justices, what do you think you're doing here, right, they would all say textualism.
A great question we got from Denise Diskin. Do you think that Bostock renders the need for the Equality Act moot, and are there any gaps that you think a statute could fill? Brian, do you have any perspective on that?
Well, my understanding of the Equality Act is that it covers a number of different things beyond employment discrimination. Certainly the argument was made in Mr. Bostock's case that because the Equality Act and similar legislation had been offered and not passed, that it meant that Title VII did not include that, did not include the coverage. And obviously that argument was rejected pretty roundly by the majority, which talked about subsequent legislative history being, not good and not persuasive. But as far as the Equality Act, like I say, there was a number of other provisions. I don't know if Professor Garden, if you know more about the specific other protections that have been included in the most recent version.
I'm afraid not. No, I'm useless.
Another question that we got, and I was curious about this kind of in a broad extent, are there other broadly worded federal civil rights prohibitions of discrimination on the basis of sex, such as in public accommodations, that can now be read to protect trans folks? And I was wondering beyond that, I had heard one of the significant issues about this decision was just because there are so many other statutes that derive their understanding of sex and sex-based discrimination from Title VII. So Professor Garden, could you speak to that, either the impact that this decision has, broadly speaking, on statutory rights?
Yeah, I mean, I think the answer is yes, right? That, obviously there will, have to be litigation, but I think this case is an extremely useful precedent for arguing that all of those statutes that talk about discrimination based on sex or because of sex in public accommodations, in housing, should now cover LGBT folks.
Any other insight that you have, Brian?
This is not quite what you asked, but I felt like mentioning that I think that the Bostock decision is likely to be cited in many cases on a different issue, which is the issue of causation in employment discrimination cases. There's a lot of discussion by Justice Gorsuch about but-for causation, which is, during that whole discussion about whether a person's sex is a but-for cause of a discriminatory or alleged discriminatory action. And the court goes on for a couple of paragraphs to talk about what but-for causation means, because the employers were arguing, it's not the person's sex that's motivating this decision, it's their sexual orientation, and that's different. The court, looks at the fact that you can have more than one but-for cause of a decision or an action. But-for causation is not sole cause causation. And so I think the example given in the court's opinion is that, a car accident can be somebody running a red light and another person speeding can both be but-for causes of an accident. And so I expect that this explains a lot about the causation standard and how that's applied in employment discrimination cases. So I think that will also be discussed a lot in the future.
Interesting. We've got a few minutes left. If there are any other questions that anyone would like to get in. Before we conclude though, I wonder, Professor Garden, do you have any sort of concluding words or final impressions you'd like to share about the decision?
Well, I guess one thing I would say is that, even though Justice Gorsuch's opinion sort of says, this is what this statute meant in 1964, and if people had read their dictionaries carefully, they would have known that, that in fact, right, this decision wouldn't have been possible without successful LGBT advocacy, sort of moving, sort of moving the needle for, so many like institutions in our society, right, including the courts. And, in some ways, I mean that in terms of, what judges think is within the realm of, yeah, this is something I could imagine myself doing as a judge. I mean, and just sort of literally, right? I mean, if you had a series of lower courts saying, well, this doesn't seem thinkable to me, then there would have been no circuit split, no Supreme Court case, right? So, I think that gets lost in a decision that's written in the way Justice Gorsuch writes decisions, but is definitely bears talking about here.
Any final reflections, Brian? And I wonder if actually I might bother you to provide just a moment of insight into what is it even like taking a case to the Supreme Court?
Yeah, and I was, one thing I wanted to say about kind of a final reflection is that, it was always a surprise to me that you could be married to a same-sex partner on Sunday and fired for it on Monday. I talked to a lot of people over the last few years who were surprised to know that that a person could be fired for their sexual orientation. And so the thing I would say or wanted to say is that not just in the law, but also really specifically for this case, because it took so long during the process of petitioning and waiting for the court to decide whether to hear it and then all that. Sometimes, good things come to those who wait. But certainly I'm glad we're done waiting for, equality in the workplace for LGBT folks. Going to the Supreme Court was, obviously a huge highlight for me in my career and a wonderful experience. And when I was in law school, read eagerly so many of the cases that we study in constitutional law and other classes that, lead to greater protection and equal protection for marginalized and disfranchised groups. And, I have to say that, you practice law and you have bad experiences sometimes with cases and clients and just situations. And, this was the kind of experience that really, kind of inspired me or motivated me or buoyed me all over again for all of the work that we try to do and which we try to do in the Civil Rights Division of the Attorney General's Office to advance civil rights protection for folks. So it was very, it was really, it just gives me a lot more motivation to know that, that an outcome like this can be had by advocacy and hard work and all of the above.
Is definitely a lesson for that. Thank you both so much for joining us. Thank you to everyone who attended, and I'm sure we all learned a lot from this decision. I really appreciate both of you. Before we go, I wanted to give a quick plug to QLaw Bar Association's sister organization, the QLaw Foundation, particularly the legal clinic that they run. Though this decision has a monumental impact on the rights of the LGBTQ folks, there are LGBTQ folks across the state who need our legal assistance every single day. The legal clinic is a great opportunity if you're interested in serving any of those individuals, or if you would just like to see the incredible work that they have been doing, particularly during the time of the coronavirus. Really proud of all the work that they're doing. Thank you again for joining us, and we hope that we will see you all hopefully in person again soon. Take care.
Thank you.
Bye all.